The courtroom is where justice reigns, and not even the most corrupt cops can escape it. Watch the most satisfying moments as these dirty cops get completely owned in front of everyone. Like this first cop, who couldn't believe the massive sentence he got for his horrible crimes.
Count 29, rape first degree. Defendant is guilty of the crime of rape to first degree.
From jaw-dropping expressions to unexpected outbursts, you won't believe how these former enforcers of the law handle their reckoning. Today, we're exploring how dirty cops react when justice catches up with them, facing the ultimate consequence: life sentences. In December 2015, Daniel Holtzclaw was convicted of the 13 that he was accused of earlier that year, and the following is footage of him regretting what he had done when he found out what grave consequences he'd have to face.
All rise. The Honorable Timothy R. Henderson presiding.
Thank you. You can be seated. All right, ladies and gentlemen, let me first make an announcement that we have to have order in this courtroom. There can be no outbursts. There can be no disruptions. If anyone gets out of order, you will be taken into custody immediately and removed from the courtroom. With that, has this jury reached a verdict?
Yes, Your Honor.
All right, would you hand your verdict forms to my bailiff, please?
As you can see, even before the verdict, Holtzclaw was terrified because he knew he had committed all of the crimes. But a monster like him wouldn't feel guilty about his actions. He was just not ready to face the karma of what he had done.
All right, the verdict seemed to be in proper order. This is in the District Court of Oklahoma County, State of Oklahoma, the State of Oklahoma versus Daniel K. Holtzclaw, case number CF 2014-5869. Verdict, count 1, sexual battery. We, the jury, impaneled and sworn in the above entitled cause, do upon our oaths find as follows. Defendant is guilty of the crime of sexual battery and set punishment at 8 years. Count 2, procuring exhibition. Not guilty of the crime of procuring exhibition. Count 3.
These are crocodile tears, not genuine ones. No one pitied this monster because of the terrible sins he had committed. You'll see that the verdict couldn't have been more just.
Defendant is not guilty of the crime of first degree, nor lesser included. Count 4, procuring exhibition. Defendant is guilty of the crime of procuring exhibition, and punishment is set at 5 years. Count 5, procuring lewd exhibition. Defendant is guilty of the crime of procuring exhibition, and punishment is set at 5 years. Count 6, defendant is not guilty of the crime of stalking. Count 7, defendant is not guilty of the crime of sexual battery.
By the time the judge finishes, you won't be able to count on both hands the number of crimes this man has committed.
Count 8, defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 20 years. Count 9, rape first degree. Defendant is not guilty of the crime of first degree. Count 10, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 11, rape first degree. Defendant is guilty of the crime of first degree, and punishment is set at 30 years. Count 12, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy.
I can't comprehend how he can't even feel emotion. Did seeing the helpless faces of those women not trigger anything inside him, make him stop himself from raping his next victim? Nothing stopped him. He didn't feel emotion then. How does he feel it now? How does he only feel bad for himself?
Count 13, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 14, battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 15, procuring exhibition. Defendant is guilty of the crime of procuring exhibition, and punishment is set at 5 years. Count 16, forcible Defendant is guilty of the crime of forcible oral assault. Punishment is set at 16 years. Count 17, forcible oral. Defendant is not guilty of the crime of forcible oral.
The judge barely had time to catch his breath before moving on to more of his crimes because of the sheer amount of them.
Count 18, procuring exhibition. Defendant is not guilty of the crime of procuring exhibition. Count 19, procuring exhibition. Defendant is not guilty of the crime of procuring exhibition. Count 20, rape degree. Defendant is not guilty of the crime of rape first degree. Count 21, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 22, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 23, sexual battery. Defendant is not guilty of the crime of sexual battery.
My question is, when you've done even a quarter of these many sins, you know something bad will come, so you'd better be ready for it. But this man, you can't call him a sorry person. This monster was crying like he didn't see any of it coming at all. How dumb was he to think he could have gotten away with everything?
Count 24, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 25, rape second degree by instrumentation. Defendant is not guilty of the crime of rape second degree. Count 26, indecent exposure. Defendant is not guilty of the crime of indecent exposure. Count 27, forcible sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 28, rape first degree. Defendant is guilty of the crime of rape first degree, and punishment is set at 30 years.
It's just amazing to see that he was getting what he deserved and justice was being served. Watching these evil criminals get owned in ways they couldn't even imagine is incredibly satisfying.
Count 34, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 35, defendant procuring exhibition. Defendant is not guilty of the crime of procuring exhibition. Count 36, procuring exhibition. Defendant is not guilty of the crime of procuring exhibition. Let me ask the jury, is this your verdict, so say you all? All right. Counsel, would you like to examine the verdict forms?
Not to say no.
All right. Mr. Holtzclaw, you and your attorneys just come forward. Mr. Holtzclaw, this jury finds you guilty of the various counts. You will be remanded to the custody of the Oklahoma County Sheriff for formal sentencing set January 21st, 2016 at 10 o'clock a.m.
Your Honor, I'd ask to poll the jury.
To sum it up, he got 263 years in prison. He could die thrice and still have time to spend in jail, completely deserving of a behemoth like him. Despite him being a cop, he was given no privilege, and this is exactly how the judicial system should be. Up next, we have a cop who thought he could hide things from the higher-ups, but he was dead wrong.
Approximately how many rounds of ammunition did you find?
Approximately 5,000 rounds.
In April of 2024, former FBI agent Todd Brown took the stand and discussed his search of 4 of Jamie Knoll's properties. Jamie Knoll, a former Clark County sheriff, was accused of using a business card for personal purchases and having sheriff's office employees work at a barn of his. However, the extent of his corruption will leave you shocked.
We had contacted Mr. Todd Brown, a retired Federal Bureau of Investigation officer, who we asked to conduct the search. Mr. Brown conducted the search, and pursuant to the court order, we filed on May 1st a copy of the report along with an exhibit that identifies all of the items that Mr. Brown located in the house, and we would like to call him as a witness, Your Honor, to have him detail for the court the location and the items that were taken.
You may.
Thank you.
Mr. Brown? Please have a seat. Would you raise your right hand? Do you solemnly swear or affirm under the penalties for perjury testimony you're about to give to be the truth, the whole truth, and nothing but the truth? Thank you. Have a seat. Your witness, Mr. Bowles.
Thank you, Your Honor.
Todd Brown would reveal some shocking things he found during his search.
Mr. Brown, when I contacted you, I asked you if it would be within your capacity to do an inventory of all our client, Jamie Knowles' properties that he owned for the purpose of securing any additional weapons that might be there, even though the court didn't authorize that, also to indicate whether any ammunition located in those locations. Is that correct?
That's correct.
Also, I've asked you that you were aware at the time that you were going to do the search that Mr. Knoll was given permission by this court to have a shotgun at the residence. Is that correct?
That's correct.
Okay.
But a shotgun wasn't the only gun that was discovered at Jamie Knowles' properties. There was something of much more consequence found as well.
Let's start with what properties were you assigned to search?
I was assigned residence at Old Tay Bridge and a pole barn with a cabin next to it, I believe 709 Old Salem Road in Jeffersonville. The residence was also in Jeffersonville.
Okay.
Then a green barn at 711 Old Salem Road, and then a house on Turnberry, I believe it was 2408 Turnberry.
Also, they were also located in Jeffersonville?
Yes, all the properties were in Jeffersonville.
Were you able to locate any weapons in that home?
I did.
And what did you locate?
I located a Glock 26 pistol, semi-automatic pistol, a Sig Sauer 1911 semi-automatic pistol, and a shotgun.
Okay, let's be very specific on the first, the Glock 26. Did you also take a photograph of where that was located?
I did.
Okay, could we have a picture up on the screen which would be for the purpose of having you identify the area where that weapon was found, is that correct?
They did good getting a professional to investigate because no one else could find this slimy cop's secret hiding spots.
Sure.
Where was the gun located?
It was located...
Why don't you come off the stand if the court would permit and point to the photograph?
It was located in with all these items that are shoved into the closet area here.
Was it on the floor? Was it in an item, or where was it?
Actually, at the time that I located it, I was pulling items out of the closet, and there was a nylon zip case, and I opened the nylon zip case to see what was in it, and that's when there was a gun box inside the zip case. I opened the gun box, and the gun and one magazine was in the box.
Was the weapon loaded or unloaded?
It was unloaded.
Okay. Could we show the second photograph, please?
Knoll had clearly hidden the weapon in the closet. He thought it wouldn't be found, but he couldn't have been further from reality.
So, as part of your search, in searching all of the house, went to the master bedroom?
I did.
Okay, and is that the photograph of a closet located in the master bedroom?
Yes, sir.
Okay, and was there a weapon located there?
There was.
And what was the weapon?
It was a 6 Sauer 1911 semi-automatic pistol.
Okay, and where was that weapon located?
It was located in this area of the floor. There was a pile of stuff on the floor.
Was that pile on top of it?
I'm sorry.
I couldn't see.
Oh, I'm sorry, sir.
If you'll do that again from the other side.
No, I'm sorry. I located it in this area of the closet. There's a pile of clothes and all sorts of stuff there on the floor, and I found it as I was pulling stuff out.
What Knoll should have done was that he should have listened to the authorities and only kept the shotgun for self-defense. But he'd just gotten himself into unnecessary trouble. He'd soon pay for going against the orders given to him.
Approximately how many rounds of ammunition did you find?
It would be a really rough estimate. I've detailed it in my report. Approximately 5,000 rounds,
What caliber?
various calibers. They're 9mm, 45, 380, 5.56.
If the actual figure was anywhere around 5,000, that is beyond insane. What was he planning to do with so much ammunition? Go rob a bank?
7.62. That's 22. And there could be others. That's what I recall.
The two guns that you found, the Glock and the SIG,
Yes, sir.
were you told where to look for those?
No, sir.
Nobody told you to look in the master bedroom closet or the laundry room closet?
No, sir.
Did you have any contact with the defendant, his wife, or his daughter?
With his daughter.
Which daughter?
I think Grace.
What was the extent of that contact?
Just to advise that I was at the home.
Had you ever met any of them before?
No, sir.
Had you ever met the defendant before?
I do not specifically recall ever meeting the defendant.
Even though he was in law enforcement for about 30 years, that overlapped the same time that you were in law enforcement?
That's correct. I don't specifically recall meeting him.
Did you search any vehicles?
I did.
Ammunition or weapons found in any cars, trucks, or other types of vehicles?
No, sir.
He probably moved anything he had in the vehicles to the house to hide it. Unfortunately, his party had gotten busted.
Do you recall off the top of your head what vehicles you searched?
There was a Trans Am and a BMW at the residence. Then there were several, what I would call classic cars, older cars, at the pole barn at 709 Old Salem Road.
Several, more than 10, less than 10?
I would say 10 to 12.
Thank you, Mr. Brown. Nothing else.
Mr. Wells, anything else?
I have no further questions. Thank you.
Mr. Brown, you retired in 2022.
Yes, sir.
Were you able to keep your service revolver or sidearm?
No, sir.
Do you have one you typically carry?
I do.
You know where it's at all times?
Yes, sir.
Did you always know where your service sidearm was? It's probably not a revolver, was it?
No, sir.
The judge was indirectly taking a shot at Noel, and it was quite amusing to see. Noel, of course, knew where all his weapons and ammunition would have been. He should have handed them in, but he didn't, so he'd now pay the price.
So to find a service revolver, I keep saying revolver, service firearm, in a duty belt with other mags, that's not too far-fetched to believe that one would know where that was at, would it? Rhetorical question you don't have to answer.
Yes, sir.
Just reinforces my decision to impose sanctions. If that prompts any further questions.
None from the
Nothing.
defense.
I do have another question or two. The Remington shotgun, was it in the box when you found it?
No, sir.
Was it near a box? A Remington firearm box?
Not that I recall.
Did it still have tags on it?
No, sir.
In reality, the shotgun wasn't intended by Noel for self-defense at all.
Where was it at?
I located it in the basement, what I generally term the theater room.
And not loaded?
No, sir.
Not much use for self-defense, was it?
No, sir.
You were in the upper area and you needed a firearm for self-defense, where would you go of the ones you found?
The closest one would be the 6-hour 1911.
Okay. No other questions? That prompts any questions.
One question, Your Honor. Mr. Brown, was there any 12-gauge ammunition found?
Yes, sir.
That's all, Judge.
Mr. Boyles, I'm not going to impose any further sanctions today because it was not certified to me that there was no further firearms. But after today, if there's any further firearms found, there will be additional sanctions. So if your client needs to tell you something, he needs to tell you right now. You need to take a few moments and ask.
I'll be happy to, Your Honor.
The judge was an absolute boss, and he was grilling Noel and his lawyer, rightfully so.
The one thing we would add, Your Honor, is the duty weapon.
Let us get back on. Okay, we're back on now. Go ahead.
The only thing we could add, Your Honor, is there's no weapons in the house now, and the duty weapon was seized on the original search. It was in the console of his car.
Okay.
So the one that was found was not the duty weapon.
Okay.
Thank you.
Yeah, of course there would be no weapons after a literal retired FBI officer conducted a search. I doubt anything remained hidden from him.
I have no questions.
Why was it in a service holster with additional mags? And you don't have to answer that.
Well, because I don't carry guns, so I don't know, Judge. I got the BB gun.
That's all right. Mr. Brown, thank you. And thank you for conducting the search for me.
However, this next cop realized just how big a mistake he had made when he landed in front of a righteous judge who was willing to show him absolutely no mercy.
The charges are perjury in the first and tampering with physical evidence. How do you plead?
Corrupt cops think they can get away with just about anything, but the courtroom is the one place their dreams of getting away with their crimes go to die. This first cop finally got caught and punished after getting away with unimaginable crimes for over 20 years. But stick around for the next case because seeing this cop get demolished in court is unbelievably satisfying.
Okay, that's what I was looking for. I'm not asking you to speculate. I'm asking you a question.
In 1992, Louisville PD officer Mark Handy knowingly and wrongfully convicted 2 men for a murder case where he was the lead detective. But this wasn't the last time he would do this.
A lot of times injustice kind of goes a lot of different ways. Yours kind of started in '93. I read some of the article that you gave me, and from my understanding, there was a gas station attendant that was killed in '93.
Yes.
Now, how was it that you came to be even a suspect in that?
Through the police systems, however they do their investigation. One officer provided some information about me, and it took off from there.
Edwin Chandler had served 9 years in jail before being exonerated in 2009, all due to Handy's lies. 11 years later, though, he got satisfying revenge.
The charges are perjury and tampering with physical evidence. How do you plead?
Guilty. Well, I think this gives Mr. Chandler some closure, it gives Mark some closure, and we can all move on.
Handy's lies and corruption led to such tragedy. However, his victims had some interesting things to say about his sentence.
And the magnitude and the weight of this is immeasurable. We'll never be able to get back what we've lost in this.
It was a combination of 62 years that were served by these men. And he only got one?
They protected a white officer. And for what? My life don't matter? Evidently it don't, because it's taken 30 years. I can't say that it feels good or that it feels bad. There's no winners in this. There are no winners in this at all.
Even though Handy was supposed to serve a year, the court offered him shocking leniency just a couple of weeks in and allowed him to serve his sentence from home.
I'm definitely upset about it because I feel like, I wasn't afforded the opportunity to circumvent the law. When these claims are paid out, that there should be a system, an automatic queue to say, look, we need to investigate these things.
There was some good news, though, because the recompense the court offered his victims was staggering.
He has been tortured for most of his life by these events. The reason the misconduct was, how widespread it was, and how obvious it was or should have been to supervise. The settlement makes very clear not only that he's innocent, which he has claimed forever, but also that this was not an innocent mistake.
The settlement here really does reflect that he was seriously wronged, but even more than that he was innocent all along.
I know for Keith, he has done his very best to rebuild his life, but every day is difficult, and he is never going to be the same, but he is doing his best to build a life for himself. But it's a constant struggle.
In total, the Louisville PD paid nearly $50 million in settlements to those wrongfully imprisoned by Mark Handy. The city of Louisville agreed to pay $20.5 million to two men who were alleged victims of corrupt former police officer Mark Handy and the department. The city paid Chandler an $8.5 million settlement after his lawyers showed Handy fed Chandler facts to use in his confession and taped over surveillance video that might have pointed to the real killer. In total, the Louisville PD paid nearly $50 million in settlements to those wrongfully imprisoned by Mark Handy. This cop got served right for ruining the lives of so many innocent men. But keep watching, because the way this next cop gets destroyed by the defense attorney in court is extremely satisfying.
Okay, that's what I was looking for. I'm not asking you to speculate. I'm asking you a question.
On February 16, 2022, Eddyville PD officer Shannon Oliver came to court to testify about a DUI incident from August 21, 2020. Unfortunately, things wouldn't go so well for him.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Please have a seat and state your name for the record.
Shannon Oliver.
Any questions?
Thank you, Your Honor. Shannon, if you would, please tell the ladies and gentlemen how you're employed.
I'm employed with the Eddyville Police Department.
Shannon, do you recall whether or not you had an occasion to be working on or about August the 21st of 2020?
Yes.
And on that evening, do you recall whether or not you came into contact with Mr. Raymond Fernandez, the defendant in this case?
I did.
Shannon, were you just working general patrol that night?
Yes.
Officer Shannon thinks that he's just about to take an easy dunk and go home, but instead he sets himself up for complete disaster.
Okay. Did you have an opportunity to observe Mr. Fernandez when you were on patrol?
I did.
Okay. And tell the ladies and gentlemen of the jury, what, if anything, drew your attention to Mr. Fernandez?
I was traveling northbound on 93 South coming into town. I was passing the car wash, which, as I'm sure probably most of you know, is tore down now. As I was passing the car wash, I noticed that there was a vehicle parked off to the side. As I continued to drive by, I noticed that there was a male standing outside of the car wash, and he was urinating on the side of the building. So I drove to the next entrance, turned around in the parking lot so I could go back and speak with the individual. As I was doing that, I noticed that vehicle was coming out of the car wash and made a left turn onto 93 South to the stoplights. Then made a left turn westbound onto 62 where I conducted a traffic stop. When I approached the vehicle, that's when I spoke with Mr. Fernandez.
And let me pause you for just a minute.
This cop paints a colorful picture of the events that took place, but soon his story will start unraveling.
So, Your Honor, or I'm sorry, Shannon, whenever you initially pulled the gentleman over, was it for some traffic offense that he committed, or was it to address, hey, let's not be urinating on the side of the car?
I was just going to address that issue.
Okay. And could you see him urinating on the side of the car wash, just driving up and down Highway 93 South?
Yes.
Okay. All right. So then you said you saw the gentleman pull out from the car wash and head towards 62.
Correct.
If you would pick up on your testimony from there about when you encountered Mr. Fernandez.
I conducted the traffic stop on 62 West, approached the driver's side. Spoke with Mr. Fernandez, and while I was speaking with him, I could smell alcohol coming from the vehicle.
Shannon tries to explain everything in as much detail as possible, but he just gave bait for the clever lawyer to use later.
While I was asking for license information, insurance, I noticed that his speech seemed to be a little bit slurred. I asked him to exit the vehicle so I could conduct some field sobriety tests. First test that I conducted was I attempted to conduct the horizontal gaze nystagmus, which requires an individual to not move their head back and forth as I conduct an eye test. And what we're trying to see is nystagmus, which is an involuntary twitching of the eyes if somebody's under the influence of alcohol. While I was attempting to do that, I wasn't able to complete the test because Mr. Fernandez continued to move his head back and forth.
His own testimony makes the cop seem so, as if he chose these ludicrous tests with the intention of arresting the suspect no matter what.
So we moved on to another test, which was a one-leg stand, which basically just requires a person stand on one leg with their arms down at their side and count out loud. During that test, Mr. Fernandez was using his arms for balance to keep from putting his foot down. We also did the walk and turn, which basically has the individual walk heel to toe as they're counting out loud. When Mr. Fernandez started that test, he lost his balance at the first step.
The cop seems to be making things up as he goes, but his far-fetched story gets caught for its craziness in ways you wouldn't even expect.
We completed the test, and based on everything that I had seen, I didn't feel comfortable letting Mr. Fernandez drive at that point. I felt like that he was a danger to himself and the others on the road if I let him leave, so he was placed under arrest, transported over to Lyon County Jail. Mr. Fernandez had stated to me that he had only had a couple of beers that night. I told him that if he had only had a couple of beers, then he would be legal to drive. Your alcohol level wouldn't be high enough to be over an 08.
This cop seems to be making the suspect's case for him, almost as if he knows what really went down.
Did you say that you smelled the odor of what you thought was alcohol?
Yes.
Is that why you got the gentleman outside of his vehicle?
Yes.
Okay. What else did you notice about him whenever you got him outside of his vehicle?
Basically, like I said, I could smell the odor of alcohol on him. His speech was a bit slurred. He was a little bit unsteady on his feet, and then, as I mentioned through the test, there were a couple things that he did that I noticed that led me to believe that he was under the influence.
At what point in time, well, let me back up. Did Mr. Fernandez admit to you that he had been drinking alcohol that evening?
He did.
At what point in time did he make that admission to you?
Well, once I was out speaking with him behind the vehicle before we conducted the test, he said, I believe he said that he had been at his brother's residence and that he had drank a couple of beers there.
Shannon seems to believe if he repeats a lie enough times, it becomes true. But lawyer Larry Foreman is about to make sure he gets away with none of his lies.
One of those tools is the detection and enforcement for individuals who might be operating a motor vehicle under the influence, right?
Yes.
And as you probably know, the agency that puts out the book is called the National Highway Traffic and Safety Administration. NHTSA also puts out several follow-up trainings. Have you completed any of those since 2007 with regards to DUI detection and enforcement? Any refresher courses?
We do the training with the intoxilizer every 2 years where we certify on that. The only required training that we have is just what we complete there at the CAT Training Academy.
And boom, just like that, it turns out Shannon isn't even up to date with his DUI training, despite claiming to be an expert earlier. But you won't expect what else he has been hiding.
So the training you just mentioned, the training that you redo every 2 years, that only has to do with the intoxilizer machine, correct?
Yes.
That's just how to operate it, make sure that you're certified, you're up to date on all the snuff.
Yes.
Right?
Yes.
Has nothing to do with going on the street and conducting field sobriety tests.
No.
Correct?
Correct.
What I'm hearing you say, and please correct me if I'm wrong, you have not had any supplemental DUI training since 2007, 2008.
No.
Okay. Now, during your training in 2007, 2008, one of the things that you were taught as a future police officer is how to write citations.
Yes.
Right? Citations are important because they document what happened with this particular case.
Yes.
Right? And so you were taught that they must be accurate,
Yes.
complete,
Yes.
and truthful.
Yes.
Right? Those are the three core principles.
Yes.
Because in the future, people would rely on the citation, on the information that you included in the citation, correct?
Correct.
Like here we are today. Mr. Wilson is relying on it, right?
Yes.
I'm relying on it. The jurors are relying on it. Right? So, and in this case, by the way, you did not have any type of body camera or in-car camera of any sort.
No.
And you did not complete any supplemental reports in this case.
No.
So all the evidence that you have completed and documented in this case rests in this uniform citation. Would that be fair to say?
Yes.
Only corrupt cops like this one can get away with such incompetence, but there is still more the lawyer has to say.
Now this is nighttime. His headlights were on.
Correct.
And after you indicated by turning your lights on that you wanted him to pull over, he pulled over very quickly, right?
Best I recall.
He didn't try to drive off or keep going.
He didn't commit any traffic violations, no.
You didn't have to use your bullhorn to get his attention.
He didn't commit any traffic violations, no.
You didn't have to use your megaphone.
He pulled over as soon as I activated my lights.
All right, so after you stop Mr. Fernandez, and he's already pulled over to the side of the road, you pull up behind him, you get out of the car, and you approach his driver's side window, right? You said, and you wrote it in the citation, his speech seemed slurred, right?
Yes.
Have you ever met Mr. Fernandez before the night of the encounter on August 21st, 2020?
No.
Are you familiar with his speaking patterns, the way he speaks?
No.
So you had no frame of reference?
No.
What you wrote down and you testified to today, that to you, your personal opinion, because that's what we're here for today, is your personal opinion as to what happened, right?
Yes.
To you, Mr. Fernandez's speech seemed slurred, your words.
Yes.
This cop let himself talk too much, and now the lawyer completely destroys the holes in his logic, and suddenly it doesn't look too good for this lying cop.
Now, some other common indicators that you look for in an individual who you suspect to be under the influence are, for example, bloodshot eyes. You did not see Mr. Fernandez having bloodshot eyes in this case, correct?
Not that I recall, no.
Another indicator is glassy eyes. Another indicator is having a flushed face. Mr. Fernandez did not have a flushed face on the night of August 21st, 2020.
Not that I recall, no.
Otherwise, we would write it down, right? Does that refresh your recollection as to what happened that night?
I guess we released the vehicle to her.
I'm sorry, I couldn't hear.
I said I guess we would have released the vehicle to her.
So on that point, the CAD is accurate.
And up next, you get to not only see this evil cop get owned, but even get physically attacked in the middle of the courtroom. Faced with the evil that turned your life upside down, it's hard for many people to keep their composure. In today's video, we'll be looking at powerful courtroom scenes revealing the raw emotions and high stakes, all in pursuit of personal justice. Starting with our first case, where a courtroom scene quickly turned into a horror show. On April 21, 2014, in the Utah State Court, gang member Sale Angelau would be on trial when a witness took the stand to testify against him. However, one small mistake from the courthouse led to things taking an extreme U-turn.
Walls.
Don't fucking move. Drop the pen. Drop the pen out of your hand. Drop it out of your hand. Stay right there. Don't move. 911.
Angelau would rush the witness stand in an attempt to attack them before being fatally shot 4 times by a U.S. Marshal. The truth was, since the court hadn't installed any drapes to hide Angelau's shackles, he was allowed to sit uncuffed to not create any bias for the jury to pick up on. But what we just saw was the result. The unidentified U.S. Marshal was cleared of any wrongdoing shortly after the shooting. Lindsay Donahue, a spokeswoman for the Marshals Service, said in a statement the video demonstrates how quickly violence can erupt in any situation. Our next case features another similar incident, but with the roles reversed and the situation all the more tragic. On January 25, 2011, Zadarius Platt was to begin his trial over the murder of his pregnant wife, Jelani Platt, when he faced someone else waiting for him there. The attacker was identified as Gerald Carter, Jelani's brother, who immediately tried to go for the killing blow on Platt. Just imagine the kind of pain of losing a sibling and multiply it by 100. That is what Carter felt at that moment.
Don't do it. Don't do it. Don't do it. Get me on. Get me on. It's on your back right now. Don't do it. Don't do it. Hold on. Give me the arm now.
Calm down. Sheriff, this is Aunt Mary. I want you to calm down right now.
You died. And you deserve it.
The pain in his voice says it all. Just goes to show how much of an evil scum Platt was, getting to just strut off while Carter was left to deal with the hole that Platt left in his heart. Fortunately, only one good thing came out of this incident. Jurors took less than an hour and a half to convict Platt of the October 2009 murder, feticide, and aggravated assault. Muskogee County Superior Court Judge Bobby Peters then sentenced Platt to 2 consecutive life sentences, plus 5 additional years on a weapons charge. Killers not only leave a trail of blood, but also the tears of a victim's loved ones. However, this next case highlights their true sociopathic nature when receiving punishment for their crimes. On April 16, 2010, a being of pure evil, Shondell Jackson, would be on trial and receive sentencing for the cold-blooded murder of a University of Milwaukee student, Nathan Potter. Unexpectedly so, the sentencing wouldn't go quite as planned.
Demonstrated to be not of caring of human life and the need to protect the community, which I also fear for with Mr. Jackson being out in the community. I am going to go ahead on count 1, the first-degree intentional homicide conviction, and I am going to sentence Mr. Jackson to life imprisonment without possibility for extended supervision. I know that that is something that is reserved for the most serious of cases, and I believe that this case rises to that level.
Court marshals quickly had to subdue Jackson due to his visible reaction to Judge Dallett's sentencing, as he was heard shouting obscenities and making an attempt to leave his chair. Jackson had to immediately be pepper sprayed right then and there, as the grief of Potter's parents and the despair in their voices can be heard in the background. Hopefully, their cries haunt Jackson forever. Dallett, her voice raspy from the fumes of the pepper spray, also sentenced Jackson to 5 years in prison for attempted robbery. In addition, she sentenced Jackson to 5 years in prison for an unrelated, non-fatal shooting that occurred the same day that Potter was killed. Our final case for the day carries this exact same sentiment, but this time better articulated by the victim's family themselves.
Stop it.
On February 14, 2023 in Wisconsin, Taylor Shawbusiness stood trial for a horrific case where she murdered her lover, Shad Thyrian, and dumped parts of his body across town. However, unsatisfied with her defense representation, she attempted yet another crime right there on the spot.
I'm looking at the week of May 15 for the trial.
Stop it. Stop it. Rachel, call.
Right before the judge was about to announce a delay of her trial, Shawbusiness attacked her own attorney, but was comically taken down by the marshal with barely a sound made. But this would not be the end of the story.
If you could just tell me your name first, sir.
Kelly Therian, Chad's uncle. I basically just wanted to say that there's no excuse for what you've done. I don't care if it's drugs or upbringing, you know. We all go through hard times growing up, at least the majority of us have. You have the opportunity to change that. You have the opportunity to, see that you have a problem.
Thyrian's uncle took to the podium in the continuation of Shawbusiness's trial and remained calm and composed as he proceeded to utterly rip into Shawbusiness in the next few minutes.
In AA, I drank for 41 years. I realized I had a problem. So there's just, basically to me, you took the easy way out. It's you did the most cowardly, weakest things that you can do possible. You meet a person in school, you say he's your friend, you become friends, you become girlfriend, boyfriend, lovers, gain his trust. An innocent person that's very kind, would do anything for you. And I believe you used that and you had this plan and took your opportunity when you did.
Both Thyrian and Shawbusiness had been abusing substances the moment before she committed the act. Given this, it was quite an accusation by his uncle to claim she premeditated it. But seeing what kind of person she was, it's not far-fetched to believe.
But I walked into a program and it's free. You can go get help and it's free. All over the place there's help. And it doesn't cost a dime, It's either, and the first thing they tell you in there, you want to continue doing what you're doing. It's going to be jail, it's institution, or death. And you chose that path, and you chose the wrong path. They sit here talking about being rehabilitated. Is Shad's mother gonna ever rehabilitate from this?
That right there is the ultimate question these criminals never bother to ask themselves when committing these acts. All I can do is wonder if they simply disassociate from their actions because fully embracing such evil in your heart is simply incomprehensible.
Don't make no sense to me even to have the option of parole to come back and to gain someone's trust like that again. And, you know, because that is like the lowest thing a person can do. You know what I mean? I just don't understand that.
Parole should exist only for people who could possibly be redeemed. I don't know if there's any coming back from what Shabiznes did.
And to make other people suffer because you are suffering is pretty So that name Taylor business fits you well. And I'm not a praying man, but after Judge Walsh here sentences today, I will pray that you meet the same fate as your idealistic Jeffrey Dahmer. So have a good life, shit.
I would argue that name didn't suit her at all, because it didn't even nearly begin to describe just how much of a terrible scum she was. However, other relatives of Thyrian had a more surprising attitude towards Shabiznes.
Before you start, if you just state your name for the record.
Michael Thyrian.
Go ahead.
Taylor, I just wanted to say that I forgive you for what you've done to my son. And yeah, you made a bad choice, and now you have to live with it. But you know, I'm gonna miss Shad. He was a wonderful child too. Growing up, just mild mannered and just happy, and I know you made a bad choice.
I will never be able to understand the kind of strength some parents can muster when it comes to forgiving people who took away their child, especially when that person is Shabiznes.
And I'm going to ask the judge if he can, you know, if she can see the streets again sometime, you know. It may not be soon, but I believe everybody makes bad choices, and maybe not to this scale, but I think there's a lot of hope for you. I think, you know, you can make use of your time and be a better person and do great things yet, you know, so.
Oftentimes, when it comes to forgiving someone, it's not always about forgiving their actions, but having the ability to let go of that baggage. I believe that is what Thyrian's father tried to do here, instead of painting Thyrian's final memory with further tragedy. A Brown County judge sentenced Taylor Shabiznes, 25, for the February 2022 killing of Shad Thyrian, 24. A jury had convicted her in July of first-degree intentional homicide, third-degree sexual assault, and mutilating a corpse. And fortunately as well, a life sentence without parole. On that note, that will be all for today's video. Let me know in the comments below which case was your favorite. And if you liked the video, subscribe so you can take advantage of the next one we have in store for you. Thanks for watching. This is Detective Mystery, signing off.